All right, good morning. We're back in Judiciary. It's April 11th, and we have a few witnesses who are testifying on S29, and they are in the Zoom. They're there, Mr. Chairman. You did? Okay, I'll mute it. So I take it you're all together as a group, so I'll leave it up to you as to whoever would like to speak first.
Thank you, Mr. Chair.
Morning.
For the record, my name is Ted Deers. I am the Assistant Director of the Water Division at the New Hampshire Department of Environmental Services, and it was an absolute pleasure to be with you this morning. Thanks for inviting us in, and just going to do this in a couple of different ways. I'll kick us off just by giving a little intro, and then, mostly about kind of how we got to where we are here in New Hampshire with these programs. And then we'll have Aubrey Volker, who is our salt reduction coordinator, and she'll talk a little bit about how this program actually works, the nitty gritty of it. And then she'll turn it back over to me, and we'll have just a couple of reflections on the limited liability relief provisions and our experience with that. And then turn it back over to Michael Johnson, who is an attorney here in New Hampshire. I think he's also in the bar in Maine and Massachusetts. And he represented a client recently on a case that went through the pretty much through the entire legal process relative to the Green Snow Pro and the limited liability relief provision. So with that, let me just give you just a quick overview of kind of how we got here. Our journey on chlorides and salt reduction began in the early 2000s with the initiation of the highway expansion on I-93. If you've ever traveled that direction down to Boston, if you've gone between Manchester and the state line, that road used to be at that time 2 lanes in each way. There was a proposal to widen that to 4 lanes each way. That has since been constructed. It was by far the largest infrastructure, by cost anyway, largest infrastructure project in New Hampshire history. With that expansion came the commensurate additional pavement, which had to be treated, had to be, making sure people were safe, parking lots, extra clover leaves, all that other stuff that goes along with a major infrastructure project. At the same time, EPA was doing some sampling in that part of our state and identified some areas that had high chloride levels. We went in, did a bunch of research, did a bunch of studies, and found out that we had 4 streams in that area that violated our water quality standards for chlorides. At that point, that made made the highway construction kind of difficult. So in order to move through that, we did a couple of things. One of the things we did was we did a TMDL, which is a total maximum daily load, which is really just a pollution diet. It's how much salt do you need to reduce to get down to water quality standards. And in doing that research, what we identified, because part of that is you have to identify where's the salt coming from by sector. And what we identified is the DOT, our highway was only about 9% of the salt. Our municipalities were somewhere around 25%, and the rest largely coming from private parking lots and driveways. So we initiated at that time a training program for private contractors to begin to reduce their salt use. And we basically stole Minnesota's program. So Minnesota had an active program. We basically just took it and didn't even really cover over the Minnesota part of it. We just used their program. And it started to get fairly popular. We had a lot of people that were interested. But what we heard from the contractors over and over again is that they'd love to reduce salt, They'd love to use the right amount at the right place at the right time, which is what our program is all about. And they felt they could still protect public safety, but the act of intentionally using less salt, they felt left them open to vulnerability to lawsuit. And so we began working on this piece of legislation that would help to provide some relief to that concern. And the model essentially we used was the ski area model, which is that it recognizes that strapping slick boards to the bottom of your feet and then skiing pell-mell through trees is an inherently dangerous activity, as is walking across parking lots in snow and ice and being out in it. And so as long as the ski area, for example, is doing what they need to do to keep their clients safe, that is that they block off areas that are unsafe, they close during windy conditions, they put padding around the poles, all of those kinds of things that you see at ski areas. The similar is true with snow removal. As long as they are meeting those industry standards, that they are meeting within the confines of their contracts with their clients or the property owners who are hiring them. The idea was that they shouldn't be held liable simply because they had used the right amount of salt and not too much salt. So that's the whole idea. That's the whole nature of the best management practices document. That's the whole nature of how this all gets tracked and everything else. And I'm going to turn it over to Aubrey. And I will just say that just from the sausage making perspective, it took us a few sessions to get this through. Ultimately, we had a champion in our Senate who happened to be the person in charge of the budget committee, who happened to also be a person who owned a landscaping company that did salt and ice removal. And so he understood the issues and understood what this was all about. It was not particularly controversial at the time. There was certainly it was the normal sort of arguments for and against. Since that time, it has been completely not controversial. We've gone back to the Senate any number of times to do corrections. We've plugged loopholes. We've cured inconsistencies and unclarity, and so every time we've done that, we've had zero controversy whatsoever. So once this sort of got into law, it's widely accepted as an appropriate and good thing for New Hampshire to be doing. And Aubrey can also talk. We just passed a new piece of this that talks about municipal snow pro. So I'm happy to answer any questions before I turn it over to Aubrey, and she can get into the nitty gritty of how a program actually works.
Yes, thank you. Senator Bohosky has a question.
A couple of questions. Does the New Hampshire limit on liability include negligence or only gross negligence?
Believe that the language that you've seen in front of you is pretty much taken directly from our law. And so but Mike can talk more about that, about how that plays in. But essentially, you do have to, the first hurdle in all of this is the negligence hurdle. You can't be negligent and claim that simply because you're a Green Snow Pro certified that you somehow are magically not liable for something. That is not how it works. And Mike can talk a lot more about kind of how that plays out in the courtroom.
Have you seen an increase in injuries since implementing?
No, definitely that has not. I think we haven't heard that at all. And I mean, this is hard stuff to track. I just put that out there because these questions come up a fair bit. Tracking litigation is very, very difficult because the systems that we have don't sort of parse out what was a slip and fall case for winter maintenance versus what was somebody who slipped in the middle of summer on some gravel in the parking lot. Those are not differentiated within any of our legal databases. And so doing that kind of research to see how did these things get, figured out is very challenging. What we do know from talking with a lot of the folks who have been certified is that there's a lot of cases that still get settled. There's a lot of cases that people withdraw, simply because once you've shown people that you have good documentation, that you know can prove that you did a good job of maintaining this parking lot, a lot of those cases get dropped. So we do have that kind of anecdotal evidence that we seem to see that there's a variety of different ways in which this plays out, none of which are radically different than before we had this law. But it certainly does bring people to get trained, and Aubrey will talk about that. And that's kind of the benefit of it, is that people, the companies themselves, are more motivated to try to reduce their salt usage, to try to save money, try to protect the environment a little bit. And the carrot that gets them through the door is the limited liability route.
Yeah, I appreciate the sort of, well, I actually, the ski resort sort of framing gives me pause, because skiing is not a necessary activity, whereas going to the pharmacy to pick up my medication and walk across a snowy parking lot might be. And so I think that using the same frame of an optional dangerous activity to set how we take care of what may be a required dangerous activity is a little problematic. But I appreciate that you gave that frame. It certainly gave me something to think about.
I can tell you, this is Mike Johnson. I don't know if you want to wait for my turn, but I can answer these questions if you want me to go now. But it's certainly, the ski resort, I think, is not, it's apples and oranges. In New Hampshire, it is, because it's, like you said, an inherently dangerous activity, the legislature decided that plaintiffs cannot bring lawsuit against them. That was what I thought this law, the SnowPro law, was going to be when it was first enacted. My experience has shown that's not the case. We, as defendants, have to prove certain things in order to get the immunity. So it's you don't see lawsuits against ski resorts in New Hampshire for the reason that that statute is very, very much pro-defendant. This statute in New Hampshire regarding SnowPro, I think, goes along with what you're saying, is everyone has to walk to the shopping plaza. Everyone has to walk out of their apartment. This is something that is something that we have to do. Therefore, you can't make it a blanket immunity. The defendant has to prove 5 elements in order to get the immunity. It's not that easy to do. So these, and to answer your other question, these suits haven't, I haven't seen a reduction in suits since this, and reduction in claims or lawsuits because of this statute. It does provide the defendant another arrow in their quiver to defend these cases in a more appropriate fashion, and it allows the reduction of salt. And as far as gross negligence versus negligence, the New Hampshire, what you see a lot of plaintiffs will do these days, they'll file a lawsuit against a snow removal company, which we represent, or property owners, which we represent, and they will allege both negligence and gross negligence. Because then we can't file a motion to dismiss right away, because they say, well, we're alleging gross negligence, which is, and in every state, it's a higher degree of fault, more of a reckless disregard or a maliciousness type thing. But I'll back out. I just wanted to make sure we answered those questions before I got my turn.
Thank you. Yeah. So, Ms. Volker, if it's if you wanted to testify, please. Floor is yours.
Wonderful. Thank you for having us. I'm Aubrey Velker. I am our Salt Reduction and Green Snow Pro Coordinator. So I kind of manage a lot more of the admin side of this, getting our applicators certified. I apologize for the weird light. I don't know what's going on in here. It's kind of just cutting off half my face. But just to kind of give you a quick outline of how someone even gets certified, I'll start with our commercial Green Snow Pro certification program that really is with this limit to liability. We did pass the rules and adopted our municipal Green Snow Pro program back in May of 2024, which I'll touch on a little later. But for someone, to receive the certification, there's two main steps that they have to complete first. The first one is complete required coursework and pass an exam. And the second one is to submit application documents to us at the Department of Environmental Services. So for completing the coursework, we do have a variety of options, and we partner with different organizations who actually administer that coursework. Us at the department, we don't administer the coursework. We provide or partner with other organizations who have that expertise and that setup to do that. This includes the University of New Hampshire, their Technology Transfer Center. Smart About Salt up in Canada provides an online training option. We also work with SIMA, which is the Snow and Ice Management Association. So lots of different options for someone to complete their training, pass the exam. All these courses are approved through us at the department. So they have to go through us first, make sure it hits everything in our rules so that it can be approved for a Green Snow Pro course. There are training fees for this coursework, and those training fees do vary depending on which organization's administering the coursework, what type of course it is, how long it is. So that varies a lot. We do have an option that allows, especially our larger companies, to kind of save some money on those training fees. And this is our master approved trainer option. So a lot of our larger companies, that have 20, 30, 40, even 50 people who need to go and complete this training, take advantage of this. And this allows someone to apply through the department to become an approved trainer. Usually it's one of the supervisors, the owner who's been in the field for a long time, but they get approved to be able to administer the coursework to the rest of their crew. And all of the materials are provided by us, the PowerPoint presentation, exams, all that fun stuff. But they can then administer all the coursework to their crews. It allows for flexibility. They're not having to pay all the additional training fees to send 30 to 40 people to training through one of our partner organizations. Instead, it's just that person who is the approved trainer. They still have to do training through our partner organizations, kind of get that extra education, knowledge, bring it back to their company. So it is one of the ways that they can save some of that money. And then just doing the training doesn't automatically give you Green Snow Pro certification. Once someone completes their training that they have to do, they then have to send in an application as well as an application fee to us at the Department of Environmental Services. So this fee varies depending on the type of certification, and it is an annual fee. And this is the fee that really kind of keeps this program up and running, as this is a fee-funded program. But for what we call an individual certificate, which is typically the person's just kind of, they're on their own, they're not part of a bigger company, tend to do it as a side gig, kind of call it, one or two guys and a plow. This has an annual fee of $150 that gets submitted to us at the Department of Environmental Services. For our larger companies, theirs is set up a little differently. So typically they have one person that we call the master certificate holder. Again, typically going to be your supervisor, the owner of the company, someone who's really overseeing the certification, overseeing everyone. They are also responsible for submitting the annual salt usage report needed for renewing their certification each year. That has an annual application fee of $250. The rest of their crew are subordinate certificate holders. They still have to complete the required coursework, but they are not required to submit an annual salt use report. That falls under their master certificate holder. And the subordinate annual fee is $25 per person. However, we only charge for the first 4. So it's a max $100 subordinate fee, whether you have 4 subordinates or 20. So for a majority of companies, they can have an annual fee of $350 that gets submitted to the department. And again, that is separate from the training fee. And this is a certification that is annual, so they have to make sure they're renewing each year, which requires them to submit a few different documents to do that. It includes a renewal application, includes an annual salt usage report, the annual application fee. And in addition, they have to make sure that they're doing continuing education. So training coursework is required every 2 years for them to maintain that certification. Again, they do need to do this every year. So we have had cases where someone has a slip and fall claim, They reach out to us asking to make sure they have all their documents, but turns out they never actually renewed their certification. So they're not covered with that limit to liability. So it's really important that they're making sure they're getting all the renewal documents in every year, as their certificates do expire June 30th each year. And then just a quick touch on our Municipal Green Snow Pro program. Municipal just got passed May 2024, so we're excited to see that grow this kind of next winter season. That is set up slightly differently. For this, we are certifying a municipality as a whole versus each individual person. So it's going to be certifying, City of Portsmouth, City of Dover as a whole for Green Snow Pro certification. All of their winter maintenance employees still need to complete that required training, but it's up to that municipality to make sure they're keeping all those documents in case we have a request to see them. There are 3 levels of certification for our municipal program: standard, advanced, and expert. For all these levels of certification, they need to do all the training as required. They need to submit a salt reduction plan that needs to be updated every 5 years. They have requirements for storing all their de-icing and anti-icing materials, documentation requirements for calibrating their equipment, and then it is an annual application fee of $450, and that's for any municipality, no matter what the size they are. If a municipality wants to do an advanced or expert certification, go kind of above and beyond, then they pick from a list of best management practices to implement and document. We have a large list of these BMPs that they can choose from, really because depending on the municipality is going to depend what best management practice works best for them, depending on their budget, type of roadways, all that stuff. So it allows for some of that flexibility. Again, this was just introduced last year, so we're excited to see that kind of grow this year and get municipalities into the program as well. But with that, I will definitely open for questions. There's lots of moving parts, but happy to answer questions, or if we want to talk more about limit to liability as well, we can do that.
Senator Bolte has a question.
I have a couple. Is there any continuing education requirement in between certification and recertification?
Yes. So once a person completes that initial kind of full course and exam, they'd have to complete coursework every 2 years. So pretty much every other year they have to complete coursework, and we have a lot of different options to be able to do that.
We also have to, sorry to interrupt, every 6 years they have to go back through the full training, which is a 6-hour training. Is that correct?
4-hour.
4-hour training.
And is the exam the same no matter what training they go through?
It's very similar. So it's not all exactly the same. We're actually updating some of our materials too. However, we do have listed in our administrative rules 7 different topics that they have to both learn about and be tested on. So whenever an organization kind of develops maybe a new course, we make sure the exam hits all those topics that they have to make sure that they have gained knowledge of.
Okay. And has this worked to reduce salt?
That is a question that's unfortunately very difficult to answer. Salt is very hard to really track in the environment. It can actually, with specifically chlorides, it actually shows up a little later, usually a couple years down the road. So it takes a lot of tracking to actually figure out if we're seeing a reduction in chlorides, at least getting that scientific data. We do have quite a bit of anecdotal data from applicators and companies that have been part of our Green Snow Pro program for multiple years, some since the beginning, that have said that they've reduced their salt by 40, 50%, especially some of those that have slowly transitioned over to brine and liquids, which is a reduction in salt, as well as they're seeing savings in costs as well, not having to pay for all those materials.
We did do a study. Aubrey did a study. I say we because she does all the work, but Aubrey did a study with another staffer where they looked at the data that we've been collecting for salt use. And the one striking thing that come out of that is that companies that have been in our program for longer time period have a lower rate of salt application. So I think that that's a pretty good indicator that this is working, but it's very noisy because every winter is different. Every winter, we use more or less salt based on the conditions that occur. If it's warmer or colder, wetter, if you have a lot of changeover. This winter in particular, where we had cold temperatures, heat up just enough during the day to put water back onto the roads, have to hit it with salt again at night, and then repeat that process for multiple days on end. That was kind of the story of this winter, because of the snowy but cold February that we had. So it's a difficult question, but one that we continue to try to figure out.
Senator Norris, another question.
Yes, with the implementation of this program, did you find that either at the state level or municipal level, did you have to grow your workforce or be able to implement this program with existing staff and monitor it?
Currently, it's just been with existing staff. So pretty much it's just me, but I am a part-time position. Fortunately, I have some great colleagues who definitely help me out during some of our busy season. But definitely something we've discussed, have been trying to grow and get me into a full-time position, finding the funding for it.
Yeah, you may be familiar with our motto of live cheaply or die. That's the state motto. So that is so trying to build staff on this program has been challenging. I think that Aubrey does a phenomenal job, both of sort of keeping the wheels on the bus with all of the certifications. It requires us to be very accurate, because the first thing that happens if one of our certified operators has a lawsuit is that both sides come and ask us for records about whether or not they met all the requirements of the program. So that requires us to be on top of all of those and to be able to track that very well. But certainly Aubrey also spends a lot of time doing outreach, and she's sent Valentines out to various different folks about be mine, use some brine, those kinds of things. She's done Halloween themed outreach. We have lots of videos, a very popular Facebook personality. So we've done, I think that on a shoestring, we've done an awful lot. If I had more resources, certainly we would do more of that. One of the good things is that we have training partners. So while we're not doing all that training, so our University of New Hampshire Technology Transfer Center, the ones who work with our road agents, they do a lot of this training, and that's been a great partner, as has SIMA, the Snow and Ice Management Association, and a lot of other partners that we work with. So it really is it's sort of a stone soup approach, I think, that we have used here in this particular program. If I had dollars, the best thing that I would be able to do, I think, would be to do some small grants and loans for especially smaller companies that want to use advanced equipment, such as location devices for their trucks, automatic feeders, automatic tracking. There's really good plows out, live edge plows that give a closer shave on the road. There's and then of course brine and use of liquids.
So do you feel comfortable commenting on that at a municipal level as far as the workforce is concerned?
Sorry, ask that question again. I'm sorry.
Do you feel comfortable commenting on the workforce at a municipal level and how it's affected them, if it has at all?
Yeah, the municipalities so far have been, because we're just launching this program, it really, they're dealing, it's kind of a different animal. That's one of the things that we definitely have learned, is that the municipal side is very different than the private. It's different equipment. It's a different, you have a different mindset. You're working on roads instead of parking lots. They're having their own challenges. I'm sure folks in Vermont are as well, of finding people to actually drive plows these days. But the municipalities that have really leaned in to use of brine and some of the advanced technologies and being really focused on salt reduction have seen a lot of savings. There was one small town over in right on the Connecticut, actually probably looks at Vermont, in which they wanted to get a new Bobcat for their crew. So the guy who was in charge, who had been through our training, said, look, if we can reduce salt by 30%, that will give us enough money in our budget left over at the end of the year to buy the Bobcat. And so they were highly motivated. and they all went to training, and they all began calibrating their equipment, and they worked really hard to do that, and they got the piece of equipment. So it is certainly possible, and it creates some nice incentives at esprit de corps within some of these municipalities.
Thank you, and I'll try to make this my last question. So do you find for the smaller independent individual, is there a financial impact on this program for them?
I don't think so. I mean, what we have seen is some of the smaller companies actually try to differentiate themselves in the market by being sort of green applicators. There's a few of those that have really marketed themselves using this as an advantage. And most of the time they're using their training to try to reduce the amount of salt that they're using, because for them, every dime matters. And so if they could spend less money on salt, that's more money in their pocket. So if they can get the same level of service, meet their contract the same way as if you used more salt, but you can use less inputs, then you're able to have a higher profit at the end of the day. So we've not had any of that kind of pushback. In fact, it's quite the opposite. We have some real champions amongst some of those smaller companies. I don't, Aubrey, if there's anything else you want to add to that.
Yeah, I'll just add, especially I kind of got a few emails this year from some smaller people who decided they wanted to get certified and went through some of our training. I actually got some great positive feedback that they're like, wow, I went through this training. I actually learned a lot about my application rates, that I should be calibrating more. Them also being able to network with other companies and kind of learn what works best for them, different hurdles. So we've gotten a lot of positive feedback, even just from those being able to attend the trainings and gain some of that education and kind of learn what they can do now, how they can slowly transition down the road too.
Thank you.
Senator Robinson.
Do you have any data on the cost reduction of people have noticed from going through these programs, or the overall reduction in expenditures on life?
We don't have any like actual data. We have some anecdotal from specific companies who have said, like, yes, we have seen a reduction over, being in this program the past 5 to 10 years.
Okay.
There's an understandable reticence to companies divulging their actual sort of dollar stuff to the government, which I totally get. And because if we have it, it means that we're gonna publish it. We're gonna talk to people about it. So it's a really challenging point. These are the kind of things that I wish I had a better way of figuring out. And I think, in the future, I think one of the things maybe we try to do is to just a couple of thoughts that I've had is that it would be great if we had a study, a couple of interns or something, or a master's degree who's doing an MBA somewhere, who could actually go out and do some case studies, some sort of, the Harvard Business School case study kind of thing on this program and how it impacts companies. I think that would be a really interesting idea. And I also, anytime, if you know anybody at Vermont Law School who wants to send somebody to really dive into this question about how has this affected the overall tort situation in New Hampshire? I'd be absolutely thrilled to talk with them about such a study.
And do you know what percentage of your SALT applicators have gone through the training and maintain a certification?
When you talk about numbers, Aubrey, about kind of where we started and where we are today.
Yeah, so kind of back when this first started, especially if that limit to liability came into play back like 2013, we only had 35 people get Green Snow Pro certified. This kind of past current winter season, we have over 700 Green Snow Pro applicators, and that's from 136 different companies. So we have seen very significant growth in the program. Unfortunately, we don't know like how many salt applicators, winter management companies there actually are in New Hampshire. There's no actual database for that. Because again, we have some of those very large companies. We have some that's just 1 or 2 people kind of doing it as a side gig. So we don't know the actual percentage of people in New Hampshire that are even doing this. So it's very hard to know percentage of them that then have gone through the program, but we have seen some very significant growth, which is great to see. But yeah, knowing that number of exactly who's doing this would be great. 'Cause then we could also provide outreach to them, say, hey, come do this, get certified.
We did have back in 2007 when we were sort of just getting rolling on this. They did the staff then did go through an exercise where they actually went through the yellow pages. Remember yellow pages? That they went through the yellow pages throughout sort of most of the southern part of the state and tried to count the number of people in the yellow pages who were providing plowing services. And I think that they came up with a number of like 700 or 800 or something like that, but it was really imperfect. And again, I think as Aubrey noted, it's a very transient industry. There's a lot of people that come in and out of the landscaping business, and there's a lot of people that come in and out of then this sort of winter maintenance business. There are companies that only do winter maintenance. There are companies that do none of that, and so it is a really. But we think, I mean, if I had to guess, I'd say the universe is somewhere around there, and that we're hitting 20 to 30% maybe of that audience. But we also are focused in the southern part of the state. So maybe, so in terms of like what population of the state actually gets, has trained green snow pros that are maintaining their properties, I would suggest that it's much higher than that because our focus has really been in those developed areas. And we have companies that are members and really some of our stalwarts have 40 trucks, have 50 trucks. So they service, parking lots that see tens of thousands of people.
Thank you.
Did Mike have any additional testimony you wanted to provide? Or is Aubrey's testimony finished?
Am I all right? Everyone hear me?
Go ahead, Mike.
Yeah. So my name is Mike Johnson. I'm an attorney. I've been practicing since 1998. I'm licensed in Massachusetts, New Hampshire, and Maine. We have an office. My office has an office in Vermont, in Woodstock. I have colleagues that work there. But I come from this from a perspective of I represent companies that get sued. I represent individuals that get sued. And I come from this from a perspective of litigating these type of cases, both before the law was in effect and since it's been in effect. And I think what Ted said, I tried, what I'm told is the first case to go to trial on this law. And it really was an eye-opening experience in the sense that it really laid out what the defendants are required to do. So I really have 3 points that I wanted to kind of bring up. And the first is that this law hasn't squashed or quashed anyone's rights to bring a lawsuit. The cases are still coming in. The second point is it doesn't just protect large corporations. And the third point is it does not add an extra burden to the plaintiffs. As to the first point, the volume of cases, we represent individual homeowners who get sued. We represent companies that do snow plowing services. We represent large corporations. The volume of cases are still there. Plaintiffs are still bringing them. In fact, we have seen some crafty attorneys draft their complaint in such a way, if the snow removal company is not Snow Pro certified, they will claim that is negligence, that this particular this particular snow removal company is not Snow Pro certified, therefore not using the best practices, and therefore it is negligent. But when the case comes in with respect to the rights and responsibilities of each litigant, the case comes in, we as defendants will ask whether or not our client is Snow Pro certified. We'd get the documents from Aubrey's office. We'd get the documents from our client. And I have to say, in the majority of cases that we've had, because it's very onerous on the company to keep certain records, and let's face it, a lot of these companies are small companies that have 4 or 5 people working at them, they're really not the best record keepers. So most of the times we don't have a lot of the documents, even though they are Snow Pro certified, to assert fully the defense. However, if you do have a case where you have the full defense available to you in front of you, you raise it as an affirmative defense as a defendant, and as a defendant, you now have the burden of proof. So the defendant has to prove that the immunity applies. And the defendant, in our case, the judge made us prove 5 different elements to have the Snow Pro certification apply. So we bore the burden of that. And I don't know how many attorneys are in the room, but typically in cases, the plaintiffs bear the burden of proof because they're the ones bringing the lawsuit. In this defense, the defendant has to bring forth the proof. So I heard some testimony that it's going to cause an extra burden to plaintiffs. I heard it's going to keep plaintiffs from bringing lawsuits. I haven't found that to be the case. And in fact, it almost adds an extra burden to the defendants. It's not like, it's similar to the ski and equine laws in New Hampshire, where you can't sue a ski resort or an equine company for anything involving horses. Those are pretty much prohibitions to bring a lawsuit. In this law, it is more of a availability to assert certain facts as a defendant to get the immunity, which is not an extra burden to the plaintiff. So I think it allows the kind of the middle ground to allow the lack of use of the limitation of salt, but also gives these companies some sort of incentive to think that they may have that, be able to wear that crown of being Snow Pro certified and having all the facts at hand to get the immunity. The financial impact, I mean, I could tell you that just talking to clients and talking to insurance companies are very much happy to hear this law. They think it's a favorable thing, but unfortunately, I don't think the insurance companies pass those savings on to their insureds. But it is something that keeps, I think, the cost of litigation down, because it does allow us as defendants to raise it. It allows the plaintiff to think about it, and maybe we use it as a negotiation ploy. I think Ted said, not ploy, a negotiation tool. I think what Ted said is that most cases settle, and that's true. Most cases do settle. And if we have this available as a defense in New Hampshire, it allows us to argue the points. The plaintiff will argue, well, your Snow Pro certifier didn't keep certain records, and therefore he's not entitled to it. And it's a little bit of an argument back and forth, but it does allow an extra layer of protection, I think, to these defendants, if the defendants can prove it. And that's an important feature, I think, is not something that the plaintiffs have to prove. The defendants bear this burden under the law in New Hampshire, and under the law that I've read in Vermont. It's the same. I think it would be interpreted the same by the judges there.
Under the current law in Vermont, if someone had this certification and could prove they were following best practices, wouldn't they be found not to be negligent?
Well, so that's when this law first came in, that's how I thought that it was going to go, because you have the presumption that you're operating under the best practices. So that's a presumption. But the case I tried, the judge, a very, very bright judge, went through the law with us, and he came down and said that we as defendants would have to prove 5 elements. So we had to prove that they were a commercial applicator. And in this case, I represented the snow removal company. So we had to prove that we were a commercial applicator. We had to prove that the claimed injuries arose from insufficiencies or hazards caused solely by snow or ice, that the plaintiff was alleging that she was slipped on snow and ice, that the failure, the third element was the failure of us to remove the snow and ice was the result of was not the result of gross negligence or reckless disregard of the hazard. 4, that the failure and delay in removing the snow and ice or causing the hazard was the result of implementing the best practices, i.e. reducing salt. And 5, that my client kept written records describing its winter road, parking, and property maintenance practices that include the type of de-icing materials used, the rate and quantity of the de-icing materials used, and the dates of treatment and weather conditions for each requiring de-icing. So we had to bring forth that evidence. We had someone from Ted's office up here at trial to testify that these are the best practices, that these are, and then we had our clients get on the stand and offer into evidence all the records that I described in the 5th element. It's a very, it's not a, you're Snow Pro certified, therefore you're given the immunity. That's not the case. And that's what I argued to the judge. I was saying on behalf of my client, this doesn't seem like a great immunity if I have to go all the way to trial to get this immunity. And his point was, well, it's not like the ski resorts or the equine places. It's different. You bear the burden. That's how the law is written. So I could tell you during our trial, the judge, as a matter of law, found that we proved 4 of them. So the judge decided that at trial, all we had to convince the jury was of one of these elements. The judge found, as a matter of law, we proved the other 4, i.e. that we were a commercial Snow Pro applicator, that we had that the issue happened because of the snow. But yeah, so no, it's not a magic bullet. It's definitely not.
No, I appreciate that. And I'm going to reframe my question because that wasn't actually my question.
Oh, I'm sorry.
Well, I did actually really appreciate the information. My question was, under current law, without the immunity, if you could prove we're following best practices, wouldn't that also provide you release from liability?
Yeah, well, of course, right? So like if you prove, I think in each state, New Hampshire and Vermont, I'm familiar enough with Vermont, that the plaintiff would have to prove that the defendant was removed the snow in an unreasonably safe manner, or failed to remove the snow when they reasonably should have, or a property owner failed to keep their property in a reasonably safe condition. Yes, part of the defense is if you did all the things that the best practices provided, you should convince a jury that you didn't fail to do that. And I can tell you, as a person that litigated this case, that was a quandary that we had. I tried to ask the judge to allow the negligence case to go first, meaning can the plaintiff prove that we were even negligent? Because I thought, based on everything that we did and all the best practices, that the jury would find that we were not negligent. So yes, if we did all the best practices that were in place, then presumably there'd be a finding of no negligence, that the plaintiff didn't meet their burden. So I get your point, right? That you're saying that if you did everything in the law without the immunity, you should win anyways.
Exactly.
Yeah. But I think I can tell you that one of the reasons my client in that case did this, one, he's very much into green policies, but he was also very much liked the idea of the possibility of the immunity. And I think it incentivized him partially, but I think it's out there to incentivize a lot of these companies. Because I mean, tell me if I'm wrong, Ted, but I think the thing was, you guys talked about doing these, reduction in salt, and then people were like, wait a minute, we're going to get sued. And they came down with this plan of, well, if you implement this less salt and these best practices, then we can give you a little bit of a carrot here to make you to do that.
Yeah, this is the issue, is that, what we see, and has become sort of the cultural norm, and I'm sure that everybody on this call has witnessed this, that you'll go out, it's a bright, beautiful day, the snow has already receded, there's no there's nothing to slip on except for the excessive amounts of salt crystals that are sitting, rock salt that's sitting on that sidewalk as you crunch as you walk in and out of the building. That is the excess use of salt. But the reason why they do that is because the perception that there's salt there, even though rock salt without going into solution does absolutely nothing to melt snow or ice. It has to be in solution. If you can see it, it's actually not doing anything. So this idea that you have to, that because you see this pile of salt there, that you're somehow safer, is exactly what we were trying to, what this program tries to push back against. And that was the whole idea. And in fact, when we passed the recent municipal law, we also dealt with this under the sort of sovereign immunity parts of our law, in which we made it very clear that simply using less salt does not somehow make you, that just the fact that you've used less salt does not automatically make you somehow lose some of your sovereign immunity against these kinds of cases. So that was the same intent of this, was not to say to people, hey, we want everybody who plows roads to be immune from lawsuits. What it was really, the whole point of it, and I think that this is how it's now, it's what Mike found in practice, is that it's meant to, so that if someone uses the right amount of salt to get the right effect, they aren't somehow they aren't somehow held negligent. And that's the idea of the program and why it's voluntary, because we want people to, you don't want to make we thought about making this mandatory. That doesn't really work in Live Free or Die in New Hampshire, but B, it also gives people a choice as to how they want to approach this. And what we find is that people do want this. People do like this for a lot of the reasons beyond the liability relief, the community of practice that's been developed, the interactions between very large companies and very small companies as they understand more about this, the exposure to new technologies and new economies within their own companies, and then this idea of market differentiation for yourself and your company. These are all reasons why people come to the table, but making sure that simply because you use less salt, that you're somehow not more liable in court, was really important for people. And maybe it's more perception than reality, I think, to some extent, but it certainly has opened people's eyes to the possibility of improving their salt usage.
So in the instance you laid out, and actually that was my walk into the State House today, was massive amounts of rock salt that I was sliding all over trying to get in. If I had slipped and fallen on because there was too much salt, what would stop me from suing because of that?
I've had that case. I've had a case like that. People slipped on sand, and it was sand that was put down for snow removal, and it wasn't swept up, and someone slipped on the sand. I have a case where someone slipped on grass. Someone was walking down a hill next to a walkway and slipped on grass. I mean, those are two examples in Massachusetts. They're a little wacky down there, but I don't think there's anything that's going to stop a plaintiff from bringing a lawsuit. They'll find a way to do it. But I think Ted's point is, I was just up in Maine yesterday, and I was crunching on rock salt, I was thought of you, Ted, from what you said the other day, that people slip on it and people, always crunching on it. And so to answer your question, I don't think there's anything that will stop anyone from bringing a lawsuit. I think I always tell people, you could be sued for anything. It's whether or not it has merit, whether or not you can win. I think I could tell you on the grass case, which is currently going, and slipping on sand, we won that case, because we argued that we had to apply sand because it was, it was preventing, it was allowing traction for people to walk. You just happen to slip on it.
But if throwing down massive amounts of rock salt is not best practice,
nope,
then I would imagine that would be a winnable case.
Right. Well, I mean, winnable for a plaintiff if you threw down too much rock salt. Yeah, I think if they could allege that you unnecessarily put sand down or salt down in an area where it didn't need it, be a little difficult to prove. I mean, because on the one hand, you get up there in front of the jury and you say, ladies and gentlemen, what are we supposed to do? I mean, either we don't throw this stuff down and people slip on snow and ice, or they're claiming we throw too much down. I think I'd take that case any day of the week as a defendant. I think it would be a winnable case. But as far as the best practices go, and the one thing that I would say here is that the whether you can bring a lawsuit or not is obviously something that is it's easier to bring a lawsuit than win a lawsuit. So to have these things in place, instead of having to go through and prove that you did everything right, it's nice to have this little immunity position that you could take in negotiations.
Thank you, committee. Any further questions? Great. Well, thank you to our neighbors from across the river for testifying today. I believe, do we have one more witness on the Zoom? No, Mr. Chair. Right.
Well, thank you very much. I appreciate it. And as you
Thank you.
continue your deliberations, if you have any other questions, please let us know.
Great. Thank you.
Thanks.
Thank you.
Any thoughts before we break the floor?
How do we get this bill? Just for the liability?
I've been asking myself. No, we got it for the liability bills.
Okay. Do we have the bill, or we're supposed to send it back to A?
Yeah.
And I still have concerns about how broad reaching. So I actually think you should have to prove that you did things the right way to not be held liable. And I would.
Guilty.
Hmm?
Wouldn't that be like guilty until proven innocent?
For the rebuttal presumption. or
Yeah.
whatever. So, yeah, I appreciate the concern, but I don't necessarily use me to come on the subject.
Can you say what you said one more time?
I said that if you're going to be not held liable for doing damage, I think you should have to prove that you have done things the right way.
My understanding is I think that you would still have to prove that in order to, at least as how this is written, you would have to prove that in order to get the immunity. That's my understanding.
I mean, that's not what the attorney just said. The attorney just said, rather than having to go through and prove you did everything the right way, this immunity is a nice thing to have.
No,
I'm pretty sure he said the opposite.
he said
That's not what I heard, but I'll go back and watch it again.
Is he still on the Zoom?
He said he had to prove 5
Yeah,
things.
part of things,
Yes, he did say he had to prove 5 things. But what he just closed out by saying is, rather than having to prove that you did everything the right way, this immunity is a nice thing to have.
I think he was talking about if you didn't have an immunity, like if there was no bill.
Yes, that's my point. I
No,
think
but
you should
still-
have to prove that you did.
You still have to, in order to get that immunity. The judge made him prove 5 things, and in the end, he had to prove 1, or the jury had to accept 1 of them.
I could probably support it if it still included negligence, but I just think gross negligence is too high. Or if
It's,
if
I think
it,
it's the opposite.
so yes, I worded that. If it did not include negligence, I could support it. But as it is, I think I have concerns.
So you want gross negligence versus negligence, that's what you're saying?
That is what I said, but it's not what I meant.
Just checking on it.
When, when I restated what I meant is I don't think liability should apply to negligence. It currently does. And we are only sort of limiting out gross negligence. Like, I think you should be held accountable if you acted negligently.
Other thoughts?
I was just rather surprised about all the hoops that that attorney had to go through, all the levels that he had to prove for his client to be able to get that. Because I reading this bill going into it, I thought it was, oh, you're doing all these good things, all right, you're covered. But then having to go all the way to a trial.
Well, maybe fewer times have to go because of the presumption. In other words, the plaintiff's lawyer would know that if you had this law in place, the plaintiff would be in weaker position. No,
They still had the same amount of cases.
Fully understand. I don't fully understand.
In other words, it seems like this bill could have two effects. One is to protect the person to a certain extent from lawsuits. But maybe fewer lawsuits would be launched because they're not as effective after this bill passed.
But at the beginning, you said that wasn't the case. They're not seeing a difference.
It seems to me like they didn't know yet.
That's the other thing is they couldn't answer any questions about, is this effective? Is this harming people? Like, there's no information.
Right.
Yes, I have to know exactly what the bill is doing because I don't have a problem with someone being held responsible for negligence on their part. But once again, I'm of the opinion that if you're accusing me of something, you need to prove to me or to the courts that I was negligent.
Yeah. And I think that's still the case.
I think this bill would make it so that the defendant had to prove.
Right. So we're, need some clarification.
Boy, we are confusing ourselves.
We are, don't take much of that.
I'm in it for the less salt. Because I think that's just a horrific problem that we turn our blind eye to. How much salt goes into the lake, how much salt gets spread on road sidewalks, goes into the groundwater.
Yeah, and then the accompanying problem is the concern of at least a perceived risk of increased liability if less salt is being laid.
Right.
And whether that, increased exposure for plow drivers or the property owners.
I don't know who would give us this information. Maybe it's ANR. So somebody testified that most of Vermont's salt is coming from the highways. Do we have the data as to where the salt is coming from? Because if it's coming from the highways, that's our state employees. We could just say, you need to do these things. So I'd like to know, because I also want to decrease salt. I want to be clear. I also want to decrease salt, and there is no data to show that this does that. I would like to know, in the state of Vermont, where is the vast majority of our salt usage occurring?
I think the attorney that first testified was the one that brought that forward to us about the state roads and dumping, this dumping warrant.
Yeah, I would love to see if that's.
First, he was an elderly gentleman, he's been
Yeah.
practicing for 40 years, and he's lawyer on that board.
Yeah, we can ask ANR.
What's our salt policy here? Safe roads and safe speeds? Is that our motto?
I believe it was,
Some of it?
oh my goodness, it is some safe roads, not clear roads. I can't remember, but it is something.
Yeah.
Safe roads, not clear roads.
It's something, because I remember hearing it and I was like, that's ridiculous. A clear road is a safe road.
I remember
Safe roads and
Massachusetts
safe
has a
speeds.
clear road policy, and I remember
That's what someone said to me when because I talked about, they said, well, we have a safe roads policy, not necessarily a clear roads policy. And I was like,
And I remember back in the trooper days, we would often have to just park within a couple miles of the Massachusetts Vermont line because people would be flying up the interstate in the middle of a snowstorm in Massachusetts and hit Vermont and then go out of control. So we're driving too fast for the conditions. So we'd have dozen crashes right at the Vermont, Massachusetts portion.
I like the day in Massachusetts.
Yeah.
yeah,
They're wacky down there.
That's from us.
you are right.
You
Safe
can say
roads,
that.
safe speeds.
Is that what it is?
Yep. Adopted by the General Assembly in the 1980s.
Safe roads, safe speeds, that was it.
Yeah, safe roads and safe speeds.
What about moderately safe roads?
At moderately safe speeds.
Enough roads.
Yeah, Vermont does not have a bare roads policy. They have a safe roads policy. This is on the same page.
So we'll talk to A&R. We can
Maybe AOT.
take their bill back. Okay, we can go on.